This is a breaking news alert. Special counsel Jack Smith has now secured a new indictment from another grand jury in Washington, D.C. against Donald Trump for his efforts to overthrow the results of the 2020 election. In legal parlance, we call this a superseding indictment in that it supersedes the prior indictment that was brought against Donald Trump back in 2023 for Trump's attempt to overthrow the results of the 2020 election. Special counsel Jack Smith had to conform the original indictment to the Supreme Court's ruling, where the Supreme Court found that Donald Trump was entitled to absolute immunity. But folks, this grand jury had been meeting in secret. The indictment just dropped. This shows special counsel Jack Smith is not backing down after the Supreme Court ruling, finding that Donald Trump has absolute immunity. What special counsel Jack Smith just emphasizes in this superseding indictment is that Donald Trump was a citizen and a candidate. Sure, he happened to once be disgracing the Oval Office, but this superseding indictment makes it clear he was a citizen, he was a candidate, his conduct, his crimes were not within core constitutional functions or official acts of the presidency. Now, just a brief reminder of what went down. Special counsel Jack Smith indicted Donald Trump back in 2023 in Washington, D.C. federal court. The case was assigned to Judge Tanya Chutkan. Donald Trump filed a motion to dismiss that indictment on absolute immunity grounds. Judge Tanya Chutkan rejected it. Donald Trump appealed to the D.C. Circuit Court of Appeals. A three-judge panel made up of Democratic and Republican appointees rejected Donald Trump's claim of absolute immunity. Trump went to the United States Supreme Court. They found that he was entitled to absolute immunity for core constitutional functions, for official acts, and he was given an evidentiary immunity as well from introducing core constitutional functions and official acts into criminal cases against him. So, special counsel Jack Smith previously requested an extension of a status conference that was supposed to be held in the past few weeks. Why was he doing that? Well, now we know he had impaneled a grand jury to indict Donald Trump again to conform to the Supreme Court's ruling. Before the superseding indictment dropped, special counsel Jack Smith gave this notice of superseding indictment that was filed on the same federal docket where the original case was brought. Here's what it says. Government's notice of superseding indictment. Today, a federal grand jury in the District of Columbia returned a superseding indictment, ECF number 226. That just means it's the filing number 226 in the same docket from the 2023 case, charging the defendant Donald Trump with the same criminal offenses that were charged in the original indictment. The superseding indictment, which was presented to a new grand jury that had not previously heard evidence in this case, reflects the government's efforts to respect and implement the Supreme Court's holding and remand instructions in the Trump v. United States Supreme Court ruling. The government does not oppose waiver of the defendant's appearance for arraignment on the superseding indictment. In other words, they're not going to make Donald Trump show up. They're going to agree that this could just be, he could just enter a not guilty plea without showing up if that's what he wants. As this court directed, the government will confer with defense, with Trump's lawyers, and make a joint proposal to the extent possible regarding pretrial litigation in the status report due Friday. So let me share with you right now some of the major differences in the superseding indictment and from the original indictment. Let's pick up the superseding indictment right here. What you'll see is it starts with the following. The defendant, Donald Trump, was a candidate for president of the United States in 2020. He lost the 2020 presidential election. Despite having lost, the defendant, who was also the incumbent president, was determined to remain in power. So for more than 2 months following Election Day on November 3rd, 2020, the defendant spread lies that there had been outcome-determinative fraud in the election and that he had actually won. These claims were false, and the defendant knew that they were false, but the defendant used his campaign to repeat and widely disseminate them anyway, to make his knowingly false claim appear legitimate, create an intense national atmosphere of mistrust and anger, and erode public faith in the administration of the election. Notice, citizen, candidate. You see that language there over and over again. Now compare that with the original indictment that was filed back on August 1st of 2023. It starts off that original indictment to 2023 saying defendant Donald J. Trump was the 45th president of the United States and a candidate for re-election. It emphasized Trump being the 45th president. And then it talks about in paragraph 2, despite having lost, the defendant was determined to remain in power being in for president. So for more than 2 months following the election day, the defendant spread lies that there had been outcome determinative fraud. You see, the language is similar, but in the superseding indictment emphasizing this is not in his official capacity. He was a candidate and he was just a citizen. So now you go over here, as my dogs are barking, but we go over here, ignore the dogs barking, and it says the following in paragraph 3. As a candidate and a citizen, the defendant had a right, like every American, to speak publicly about the election and even to claim falsely that there had been outcome determinative fraud during the election and that he had won. So notice again the language there. As a candidate and a citizen, the defendant had a right. I shouldn't have said ignore the dogs. We can enjoy the nice little cute barking of the dogs as we go through the superseding indictment of Donald Trump. You see, they concur and they agree right there. Going through the superseding indictment as well, one of the major differences as well that Kyle Cheney points out and that we identified at the MeidasTouch Network is that Jeff Clark, co-conspirator number 4 in the original indictment, and the details about Trump's effort to commandeer the Department of Justice in support of his efforts have now been removed from the superseding indictment. And again, there's the additional language of Trump as a citizen and Trump as a candidate as opposed to Trump being in office. Now, one of the things here as well, why would they remove the allegations of Jeff Clark commandeering the Department of Justice to send letters to the states commanding them or directing them to declare there was fraud in the 2020 election when there was not? Because in the Supreme Court's opinion, Justice Roberts, Chief Justice Roberts, very bizarrely, and you may remember our breakdown here about it, said that one such act that would be considered official is when Donald Trump or a president consults with their Department of Justice and asks that they do things on his behalf. You may recall when we analyzed that Supreme Court ruling, we said not only is that just a very odd thing to say, it seems to contradict years and years, in fact, all of the precedent that the DOJ and the presidency are supposed to be independent of each other. Right? And so the very fact that the Chief Justice Roberts would act like there's no independence at all is definitely something that we flagged right away and that we thought that there was a major issue about. But Special Counsel Jack Smith is undeterred. One more point I want to discuss as well. If you notice in the superseding indictment, Jack Smith did not shy away from bringing 18 U.S.C. Section 1512 C2 claims. Again, you can see it right there at the top and in the caption, right? That is the obstruction of official proceeding charge, right? Carries with a 20-year sentence. Now, you'll also remember the Supreme Court in the Fisher versus United States case said that 1512 C2 has to be related to documents. And they said that if it doesn't relate to the obstruction of actual documents, you can't bring that charge, which resulted in a lot of cases, or some cases, being dismissed against insurrectionists who may have obstructed an official proceeding, but who did not do it in connection with documents. What Special Counsel Jack Smith is also sending a message here with the superseding indictment, not removing the 1512 C2 criminal charge carrying with it 20 years, is that he's undeterred after the Fisher ruling to continue prosecuting Donald Trump on that basis. Once again, a new grand jury has indicted Donald Trump moments ago on these same 4 charges. Slight tweaks in the allegations, but Jack Smith is ready to go. That's why he wanted the delay. This is big news, folks. Hit subscribe. Let's get to 3 million subscribers together. Thanks for watching.
Real quick, Meta just changed their algorithm to suppress political content. Please follow our Instagram at MeidasTouch right now as we head towards 400,000 followers so you don't miss a beat.